strap in, folks, because what you're about to witness isn't just courtroom drama, ... It's a masterclass in contradiction, emotion, and legal tension. Today's case, People versus Shrano Johnson, a man accused of violating his bond by drinking alcohol. But it's not just about alcohol. It's about trust, truth, and how far someone will go to dance around the facts. The judge, razor sharp; the defendant, defensive and dodgy. And the story, it starts with O'Dowd's, but ends somewhere much more serious. Stick around to see if the court shows mercy or shuts it down. Who's really telling the truth? And what's the consequence of lying under oath? You won't believe how this unfolds.
I'm going to ask this question. He presumably, he has indicated that he had O'Douls. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
Then why'd you tell everybody O'Doul?
I had O'Douls first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No. Hey,
I had O'Douls.
Are you
I had beer.
Tell me that? So did you tell them that?
Yes.
That you had O'Douls first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beer.
Hold it. You know what, sir? Don't play fast and loose.
I got
The
you.
story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because
What?
you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour
No. I didn't have
in
that.
order to reach that level,
Sure.
and could not have used the bathroom because you couldn't eliminate in order to get to that level.
Let's pause here. Did you catch what just happened? The judge did some quick math and exposed the lie brilliantly. She pointed out that to reach Mr. Johnson's blood alcohol level with non-alcoholic O'Dowd's alone, he would have needed to chug 25 bottles in an hour and never use the bathroom. That's not just biologically absurd, it's legally reckless. This isn't just a simple omission anymore, it's perjury adjacent. And when the judge says, "That's how stupid your story was," she's not being cruel, she's being factual. This was an attempt to mislead the court, and in the justice system, that's a big deal. Let us know in the comments. Do you think Johnson was intentionally lying, or just scared of the consequences?
He is.
Really?
He's
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he is asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have some concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Yeah, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked.
So there it is. The gavel has dropped, and Johnson's bond revoked. The court didn't buy the backtracking, the O'Dowell's cover-up, or the emotional appeals. And that line from the judge, he first has to admit that he has a problem. And the way he does that is he stops lying, cut through everything. This wasn't just about alcohol. It was about credibility. A reminder that in the courtroom, truth matters. What do you think? Should the judge have given him another chance? Or did she make the right call? Let's talk in the comments. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts below, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. See you in the next one.